The U.S. Representative George Miller, who's the chairman of the House Education and Labor Committee, is the lead sponsor of the 401k fee disclosure legislation. But earlier this month, Senator Max Baucus, I think is pronounced his name, introduced a proposed change to the legislation that included the elimination of the requirement that 401k type plans disclose all fees that participants pay. Now, Miller, however, called the elimination unacceptable, and he vowed to keep his efforts to reform what's going on. What is your take on both Miller and Baucus's position?
It's a very interesting development, largely because they're both Democrats, and so you think that they would be on the same, thinking in the same direction. Miller is obviously has been a proponent of transparency in the 401k area for a very long time. Baucus, as head of the, Finance Committee, has taken the view that there are proposed regulations issued by the Department of Labor sometime in 2008. The General Accounting Office has issued various reports on this issue over the last couple of years and are also pushing for legislation in the area. And the Department of Labor also has sought comments on its proposed regulations and is looking towards issuing final regulations in the near future. So I think Senator Baucus is thinking this issue needs to be vetted some more, and maybe we should not run to enact legislation that may be very harmful to the investment community. I think the issue is not dead, despite the failure to get this measure through in this last legislation, the American Jobs and Tax Hole Closing Act of 2010. But we will see persistent litigation in the area, and I think that we will see some legislation in the near future that imposes requirements on not just the fiduciaries, but the non-fiduciaries that I've been talking about to make disclosure. And in this regard, I just want to say one thing, that Putnam Investment just last week decided on its own and without government mandate to disclose all of its fees, to break down for the employer those fees that are administrative fees, those that are investment management fees, those fees that are bundled up in revenue sharing provisions, in the spirit of good faith. Also as a marketing technique, I'm sure, but it is providing employers with that information, and within the next 6 months, it projects it will be providing all of its employees, all employees who are participants in plans, similar information.
Sounds like anticipatory intelligence.
I think that's a good term, yes.
All employees who maintain 401k plans, and including all fiduciaries of those plans and record keepers and all the people that you've kind of included in this lump of hands, they all seem to be rather vulnerable to class action suits. And although, we don't have enough time to go through these suits in great detail, in general terms, do you anticipate a significant increase in these suits in the next few years?
Well, if there is no legislation addressing this issue, I do. But I want to say one thing, that the real vulnerable folks are the plan sponsors, the employers, and the board of directors. Because, as I noted earlier, the other folks, the record keepers, the third-party service providers, the even custodial banks, are not fiduciaries and thus are not subject to ERISA's fiduciary requirements. So they're in the clear. Of course, with employers looking more closely at the contracts, which unfortunately they have not done in the past, they've just signed these contracts without looking at the fees in a very minute way, granular way. I think that these third-party providers will respond to the participants' concerns and may make the same kind of modifications that Putnam Investment is doing. But if they don't, I do not think the litigation is going to go down. Rather, it will continue to go up. There were at least 20 since 2007.
Do you think that employers and fiduciaries who are unaware of these fees, do you think they have a responsibility? Is it that they're not doing their job because there's so many people touching this?
Well, I don't think it's that they're not doing their job. I think that, in simple terms, you might put them into two camps. There are those employers who make the selection of investment funds and they tell their employees where the money will be invested. There are other employers who say, here are 20 funds. You get to select where you want to invest. Here's some education about this. Here's fee and expense disclosure. Here is a voice response system where you can give your instructions and change your mix of assets on a daily basis. And it's the second group of employers who probably have been protected by the regulations currently because they have passed the buck to the employees. They said, we've given you the options, we've given you all the information, as much as we have, you make the decision. It's those other employers who are making the decision on behalf of their employees who are more vulnerable and perhaps are not educating their employees as much as they should.
Intuitively, when we think about lawsuits in this area, we think about the employees, the people, filing suit against whomever is involved in these fees. But do you see that the employers may become a little more aggressive and try to flex their fiduciary muscles to actually make claims against the record keepers or any of the other people that are involved under the ERISA plan that have these fees and have hid these fees from the public?
Yes, I think that's a real possibility, Mark. Particularly, this is a trillion-dollar industry, the fees and expenses industry. And with employers, the first line of attack by employees, I think that the employers will now look to the other contractual parties here, the investment managers, the custodians, and the record keepers, and say, where's the beef? What are we paying for, and what are we getting for the amounts that we're paying you? On the other hand, it is the employers who have the obligation in the first instance to ask those questions. So if you don't ask the question, you can't go back to the other party and say, why didn't you do this? So it's a double-edged sword. They may go after for contribution, from the record keepers and so on, but they first have to ask the questions.
I see a difference between large employers and small employers. And when I talk about small employers, I'm not really thinking about mom and pop businesses, but I'm thinking about small and medium-sized businesses that are privately owned. And the truth is they have few, if no people, that are solely responsible for these benefit plans, whether they be part of the 401k or other type of employee benefits. Do you see a change in the trend on how benefits are administered in small and medium-sized businesses as opposed to larger businesses?
Yes, I think that the change will be increased reliance on independent consultants, on lawyers, on accountants. It is no longer sufficient to just set up a 401k plan, a prototype plan, talk to Fidelity or to Putnam or to Principal Finance or any other entity offering funds for investment and say, well, what do you think? And what's the contract? How much do I owe you on an annual basis? And shut the door on that. Now it's going to require an employer to get somebody else in there to look at the contract and say, well, let's see, what are you buying and what are you paying for what you're buying?
Your point is so clear because in many instances, people do use these canned plans, and the resellers of these plans, their marketing technique has always been, hey, this plan has already been pre-approved by the Internal Revenue Service or whomever, so it's a valid plan. And true, the plan may have all the attributes of a valid plan, but that doesn't mean that the fees that are being charged and how it's being run is best for the employer or the employee, actually.
That is true. So it just means a little bit more work on the part of the employer.
All right. Well, Miriam, thank you so much for joining us today. Our guest today has been Miriam Schindel of the law firm of Hinman, Howard, and Kattell. If you have any questions on hidden fees and 401k plans or any other employment legal matters, I'm sure Miriam will be happy to assist you. You can reach her at her White Plains office at area code 914-694-4102. As always, our audience is welcome to contact our office with any questions or comments. Stay connected with us on the web at www.msgcpa.com, We can also subscribe to our newsletter, Forensic Perspectives. We can also be found on LinkedIn, Facebook, Twitter, on phone, and our blog, which is forensicperspectives.com. Your topic suggestions for future broadcasts are always welcome. Until our next podcast, this is Mark Gottlieb. Thank you for joining us.
You have just enjoyed another episode of Forensic Perspectives, hosted by financial expert Mark Gottlieb. For questions and or comments regarding this broadcast, please feel free to contact Mark by phone at 516-829-4936 or via email at msgcpa@msgcpa.com. We also encourage you to visit our website, www.msgcpa.com. The opinions and commentary in the preceding program provided by our host and guests are for informational and educational purposes only and may not be their personal or professional opinion. No accounting, tax, or legal advice is being provided. The information provided within this broadcast is not an invitation for an attorney-client or accountant-client relationship. One should always seek the advice of competent professionals to assist in their specific needs. In addition, this podcast will not be updated for changes in accounting practices or law. As such, one should not rely on any information provided by this podcast. References to resources are provided solely for the listener's convenience. We have not reviewed or verified any information, advertising, products, resources, or other materials mentioned herein. This broadcast is copyright of Mark S. Gottlieb, CPA, PC, all rights reserved. Any redistribution or reproduction of part or all of this broadcast is strictly prohibited unless authorized in writing.